Ladies and gentlemen, today is a big day for the concealed carry world and signals a massive win for gun owners all over the United States of America. Today, the Supreme Court, aka SCOTUS as we're going to call them in today's video, released their ruling on the official case of the New York State Rifle and Pistol Association v. Bruen, and with it comes some big freaking news for gun owners everywhere, especially those in and around New York and possibly California and other states with similar laws. My name's Dustin with We the People Holsters, and in today's video we're going to be breaking down this ruling at a high level and going over what it means for folks not only just in New York but all around the United States of America. Let's get started. Now, a reminder here, regardless of which state in this great nation that you live in, if you happen to need an IWB holster because you want to, conceal carry your pistol, then there's a solid chance that we have one for you at www.wethepeopleholsters.com. Seriously, guys, with over like 900 different holsters, there's a ton of options to choose from. We've got holsters with lights, we've got holsters with optics, we've got holsters with optics and lights, and we have them for just your standard G43X. Trust me, I know I have one. Now, let's talk about this court ruling. To fully understand the entire gravity of the situation, we need to set the stage, if you would, to really understand the lay of the land, Lewis and Clark style, right? So here's how it works. When you're looking at state laws regarding the regulation and issue of concealed carry permits, there are two basic categories. On one hand, you have shall issue states. Those are your normal states, right? And then on the other hand, you have your may issue states. Now, what's important here is that in those may issue states, aka New York, California, etc., right? In order to obtain a permit to carry a loaded firearm in a concealed manner, you need to prove that you need it. Yeah. In fact, the now struck down law in New York read, and I quote, "a demonstrated need to carry a gun beyond the average public safety fears. This is known as proper cause," end quote. So basically the law read that in order to carry a CCW, you had to not only be at least 21 years of age, have no criminal record for that which would forbid you from owning a handgun, also be of, quote, good moral character, whatever that means, and you also need to be able to prove that your life was in danger because, well, as you guys all know, it's easy to predict exactly when and where you may need to protect yourself. Right. This, of course, coming from the state of New York, which has some of, if not the most strict gun laws in the entire United States of America, which is why this case in particular ended up going all the way up to the Supreme Court of the United States, or SCOTUS to begin with. Now, it wasn't impossible to get a carry permit in the state of New York before, but let's be real here. A lot of it was pay to play, right? If you had money and enough of it and you knew the right people, anything was possible. No, seriously, NYPD has actually been caught several times for selling CCW permits. If you don't believe me, just check out this article. What's interesting here is that this case was heard in the state of New York, right? But will likely have implications across the entire freaking country, especially those that are in heavily populated and very restrictive firearm areas like Boston and Los Angeles and California as a whole, but we'll touch on that in a little bit, right, in just a second. In a majority ruling on Thursday, June 23rd, 2022, SCOTUS struck down one of the nation's oldest and most restrictive gun laws by ruling in a 6-3 vote on the case of New York State Rifle and Pistol Association versus Bruen. Seriously, this law has been intact for over 100 years, which is almost as long as the Mosin Nagant has been used as a service rifle. That's over 120 years, by the way, in case you're curious. In their 135-page ruling document, they state that the proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense, period. Seriously, what did they think the word bear meant here, by the way? In this absolute power statement by the one and only SCOTUS, they later go on to say that, and again I quote here, "Since Heller and McDonald, the courts of appeals have developed a, quote, two-step framework for analyzing Second Amendment challenges that combines history with the means and scrutiny. The court rejects that two-part approach as having one step too many," end quote. While all that legal mumbo jumbo sounds fancy, right, and sounds really complicated, what it really boils down to is this. The Supreme Court has ruled that when the court districts around the USA are ruling on laws regarding concealed carry, they must look at the text, aka the Constitution, and related documents in regard to the history and tradition of said documents. All of this really boils down to just being a big win for gun owners everywhere in terms of overall Second Amendment rights. The impact of this ruling will undoubtedly affect not only only New York, but will also likely affect the constitutional carry rights as we know them across all 50 states. Theoretically, this ruling should mean that any legal gun owner in the state of New York should be able to obtain a concealed carry permit, but now again, we already assume that lawmakers will still make this process as difficult as possible. In fact, the mayor of New York, Eric Adams, is apparently already in talks on how they can forbid carry in some public places like public transportation and libraries and things like that. Another possibility would be for them to raise prices on CCW permits to the point of being unattainable to the average public, which already should be illegal anyway because rights should not have a cost of entry, but hey, that's a whole nother conversation for another time that we can have in a later video. Furthermore, this ruling, hypothetically speaking, should also raise questions for the citizens of other heavily regulated gun states. We're talking things like California, like we mentioned, but also Hawaii, New Jersey, and a ton more. There's a bunch of them out there, guys. In fact, we wouldn't be surprised to see something similar come to light in the state of California in just a few days. Now, regardless of which state you guys are in, one thing is for sure, today was a big win for gun owners all around the country. Which state do you think will be next to have their regulations struck down? Drop a comment down below, and as always, be sure you subscribe to the channel if you haven't already, so that way you can keep up with all the awesome We the People content that you see coming down the pipeline. With that, my name's Dustin. We'll catch you guys on the next one.